very much.
Can you hear me?
We can hear you. Can you hear us?
Yes, wonderful. Thank
Okay.
you.
I'll show you registered. Bear with me one moment.
Sure.
Let me get your registration here. We'll be a little slow for the first few, but that's okay. We're eventually gonna get there. I'll show. Since I'm taking you out of order, Ms. Katz, I need to. There we go. Okay. I'll show you registered to testify as Ellen Katz on behalf of yourself on revisions to the Congressional Redistricting Plan. Is that correct?
Yes, it is.
Please give us your testimony.
Sure. Thank you so much. As you mentioned, my name is Ellen Katz. I'm a law professor and associate dean at the University of Michigan Law School. And I'm speaking here in my personal capacity, not on behalf of the law school. I want to thank the committee for the opportunity to be here today, and particularly to Vice Chair Rosenthal for the invitation. In my brief comments today, I'm going to focus on the July 7th letter from the Justice Department to the governor and the AG of this state, providing what the letter calls formal notice of serious concerns about the legality of congressional districts 9, 18, 29, and 33. I'm going to make 3 points today. First, the assertion that these districts violate the Voting Rights Act is plainly incorrect. Second, the letter's assertion that these districts violate the Constitution is also plainly incorrect. And third, I want to point out that what the letter is instructing Texas to do, were Texas to do it, would in fact be illegal. More precisely, dismantling these districts, as the letter instructs, would require Texas to engage in improper considerations of race in violation of both the Voting Rights Act and the 14th Amendment. So just a quick note on terminology. The Justice Department's letter describes the targeted districts as coalition districts. It doesn't define that term, but that's a term that generally refers to electoral districts in which the combined population of two minority groups that vote as a bloc comprises a majority of the district's population. So just turning to my first point, the DOJ letter claims that coalition districts, quote, run afoul of the VRA. They don't. Last year, the Court of Appeals for the Fifth Circuit issued a decision called Petaway versus Galveston County, which held that what's known as the results or effects-based test set forth in Section 2 of the Voting Rights Act does not require jurisdictions to draw coalition districts. That is, it doesn't mandate the aggregation of two separately protected minority groups in a single district. Nothing in this decision, however, suggests, much less holds, that the VRA prohibits the very existence of coalition districts. The mere fact that a district exists in which two minority groups
Please
comprise
finish
majority.
your testimony, Ms. Katz. Thank you.
Okay.
I
have a
need
bit
closing
more to
sentence.
say. Oh, okay. I will just say on the voting rights point that it doesn't establish, and it's never established, a violation of the VRA. There are hundreds of these districts nationwide in which jurisdictions relying on traditional principles create these districts. The VRA doesn't prohibit them.
Thank you, Ms. Katz. I have a second registration from you. Do we have your permission to, you want to delete that? Do we have your permission to delete your second registration? Is that okay?
Of course, yeah, I might have not.
No, you're fine. You're just fine. We'll take care of that for you. Members, questions for the witness?
I have a question.
Chair recognizes Vice Chair Rosenthal.
Thank you, Mr. Chairman. Is this working? Can you hear me, Dr. Katz? Okay. And thank you, Mr. Chairman, for graciously putting these witnesses first. Professor Katz, can you please help us understand that why it's wrong that the assertion that the Department of Justice made that coalition districts violate the Voting Rights Act? I'd like you to complete that thought, please.
Sure. As I was saying, the Petaway decision says that Section 2's effects test doesn't require these districts, but there's nothing in that decision that suggests that they would that their very existence violates the Voting Rights Act. And as I was saying, is just in closing, somewhat rushed, that there are hundreds of these districts, maybe more nationwide, in which jurisdictions relying on traditional districting principles created electoral districts in which the combined population exceeded 50%, and there's no sense that the VRA prohibits them. If I may, the DOJ letter also says that these coalition districts are unconstitutional, that they run afoul of the 14th Amendment, which is separate from the voting rights claim. And more specifically, the DOJ letter says that these districts constitute unconstitutional racial gerrymanders under the logic and reasoning of Pettaway. And this statement is simply incorrect. As noted, the Pettaway results test held that the results test of Section 2 doesn't require jurisdictions to create them, but nothing in its logic and reasoning makes these existence of these districts racial gerrymanders. Racial gerrymanders occur when, among other things, a jurisdiction allows race to predominate over traditional districting principles. And there's no indication here that racial considerations predominated over traditional districting principles, withdrawing of the 4 districts that the DOJ letter targets. And in fact, Attorney General Paxton noted in his July 11th letter to the Justice Department that the chairperson of the Texas Senate Redistricting Committee testified under oath that these districts were in fact drawn in a process that was blind to race, this is a quote, and sought to maximize Republican political advantage balanced against traditional redistricting criteria. Districts drawn this way cannot, by definition, be unconstitutional racial gerrymanders. If it's okay, I'd like to just offer 2 more thoughts on the constitutional claim, if I may.
Yes.
The DOJ letter also spends some time talking about impermissible race-based considerations. And it's perhaps the Justice Department means here that there's a constitutional defect in these districts apart from whether or not they might be characterized as racial gerrymanders. And it appears to be making, or the letter appears to be making, 2 points here. One is its assertion that districts 9, 18, and 29, quote, sort voters along strict racial lines. Again, Attorney General Paxton's letter indicated that race was not considered when these districts were drawn. So as a result, what the DOJ letter is calling racial sorting is instead simply the racial composition of these districts, created in what the state said was a race-neutral process. Districts created this way don't reflect any racial considerations, much less impermissible ones. The second thing that the letter seems to be saying is that District 33 is, quote, another race-based coalition district, apparently because the letter claims the borders districts resemble those imposed from a federal court order a bunch of years ago. And just 2 quick points here. District 33 borders, in fact, are substantially different from prior iterations of the district. And second, it's simply false that race-based considerations in prior iterations of a district render unconstitutional new and different district boundaries drawn for race-neutral reasons. And in fact, back in 2022, the Court of Appeals for the Fifth Circuit held in a related context that overtly unconstitutional racial discrimination animating a state constitutional provision did not taint or otherwise affect the legality of an amended version of that provision. And if that's correct, the same has to be true for considerations that were wholly lawful when made. So in sum, the DOJ is simply wrong when it states that these 4 districts target, the 4 districts it targets violate the Voting Rights Act or the Constitution. They plainly do not, and quite frankly, it's not a close question at all. I do want to make one final point, and I do promise to be brief, and it is as follows. What would violate both the VRA and the 14th Amendment would be for Texas to do now what this letter urges Texas to do. The DOJ letter is insisting that Texas now inject race-based considerations into what Attorney General Paxton said had been a race-neutral process. The DOJ letter itself repeatedly employs race-based considerations by relying on the racial compositions of these districts as the sole basis to argue that they are unlawful. The letter then calls on the state of Texas to engage in the same race-based considerations and use them as cause to dismantle the, I promise I'm closing, but I'll just add this. The Supreme Court told us already that this approach is misguided. Back in 2009, in a decision called Bartlett versus Strickland, the court held that Section 2 of the Voting Rights Act doesn't require jurisdictions to draw so-called crossover districts, which differ from coalition districts for reasons that are not relevant here. What's critical here is that, it's for present purposes, is when the court in Bartlett said that it was holding only that Section 2 doesn't require the creation of crossover districts in the first instance, it went on to emphasize, and again I'm quoting, I think this is crucial, if there were a showing that a state intentionally drew district lines in order to destroy otherwise effective crossover districts, that would raise serious questions under both the 14th and 15th Amendment. The July 7th DOJ letter instructs Texas to do just that. That is, to do what Bartlett said would raise serious constitutional questions. The letter targets what it understands to be operational coalition districts, and it calls on Texas to alter their racial composition so as to render them ineffective as coalition districts. Bartlett indicated that destroying an otherwise effective district in this manner is constitutionally suspect. And so I just want to urge that Texas decline what I think is an ill-advised invitation to engage in conduct that at its core amounts to intentional racial discrimination. It should instead leave these districts in place unchanged. That's all I have, but I just want to thank you again for your time and the opportunity to be here today.
Thanks for bringing your expertise here today. I truly appreciate it.
Ms. Wu, for what purpose? Questions with the witness. Gentlemen, Mr. Wu, you recognize for questions. Thank you.
I'm sorry, you caught my attention. Could you, but I was not sure of the exact answer because I was thinking about what you said, but you said the doing the mapping now would be illegal. That's a very strong statement. Could you, a statement that strong, can you elaborate on that, and let's be very precise about our language?
Sure. And I intended to be quite precise about that in making that assertion. What the letter is doing is asking Texas to inject, and as I said, in considerations, race-based considerations, into a districting process that your Attorney General has said was race neutral. The letter itself is engaging in repeated race-based considerations by relying on the racial composition of each of these districts as the sole basis to argue that they're unlawful. And then it's asking Texas to now go back to the process that it says was race neutral and think about race and use race to dismantle districts that the Justice Department itself is recognizing to be effective coalition districts. Take them apart. And you can look at the decision in Bartlett. The court has made this point where it's saying, look, whatever Section 2 requires you to draw, the effects-based test requires you to draw, it's a whole different matter if you are, and this, again, I'm just going to pull up the language here from Bartlett, if there were showing that a state intentionally drew lines, the new lines that the Justice Department's asking you to draw now, in order to destroy what are otherwise effective crossover districts. They're talking about crossover. These are coalition districts. It's the same thing for every legal purpose here. That's intentional racial discrimination, or at least it strongly looks like it. Looks at districts based on their racial composition, targets them to be dismantled for that reason. It's a violation of the Voting Rights Act. It's a violation of the 14th Amendment.
So, I want to make sure I fully understand that. So, number one, the maps that we're using right now are maps that the state has specifically stated under oath and stated in public legal opinion that there was no racial consideration in making those maps, therefore making them legal, correct?
And for our purposes here, we should just talk about the 4 districts that the Justice Department letter is targeting. So the state has said we have not used race in any part of this. There's no indication that these 4 districts were drawn using race-based considerations.
And the DOJ letter that sparked this process, what the DOJ letter suggests and the solution that they offer in order to fix it is in itself racial gerrymandering, right?
I'm going to say race-based decision-making. Gerrymandering is a complicated term.
Sure, like drawing maps based on race.
It's looking at districts, counting people based on race within the district and saying, redraw these because these are effective coalition districts. That's targeting these districts because they provide a venue for effective political participation by minority voters in Texas. They're going after them. That's a race-based decision that the Supreme Court has said, don't do that, or at least, we'd be seriously worried if you were to do that. That's not what we're holding in Bartlett in related context.
So you're saying that the DOJ letter, its intent itself is unconstitutional, like their attempt to, their desire, their end goal of doing this is in itself unconstitutional, and the method by which it wants to do it is also unconstitutional. Is that fair?
I guess I would limit to the latter. Their intent, as I understand it, is to provide a basis for Texas to redistrict at this moment by saying that there's a defect under the Voting Rights Act and under the Constitution for these existing districts. There is no defect. It's simply, for the reasons I already stated,
Right.
they don't violate the Voting Rights Act, they don't violate the Constitution, the existing districts. So instead, they're saying, go look at race now and dismantle performing coalition districts, what it understands to be that. And the Supreme Court has told us that that raises serious questions under the Constitution.
Thank you. Ms. Gervin-Hawkins, for purpose.
Mr. Chair, I'd like to ask the witness a question.
I'm going to yield to you in just a second. I just want to remind everybody you must be registered at the kiosk to testify in person. The deadline to register is coming up at 3:30 p.m. Ms. Gervin-Hawkins, recognize the question witness.
Professor Katz, if indeed we went the DOJ route, would that then open up the floodgates for our state House and Senate seats also?
I mean, I think that would depend on if you were to redistrict there as well. To redistrict by targeting districts based on their racial composition in the way this letter suggests, does suggest to me that you would be causing problems. I didn't understand that the state and the state House and Senate.
Well, I'm just saying if the DOJ letter was correct, instead of we know it's illegal and not proper, but if we were to adopt this and establish a record towards this, it potentially can open up the same methodology for our state House and Senate seats, correct?
I think, if I understand you correctly, yes. I think if the logic that is underlying this letter suggesting you redistrict for these reasons were applied more broadly to other districts in the state, for the state House, the state Senate, I think the same arguments would apply, yes.
Thank you, ma'am.
Mr. Manuel, for purpose.
To ask a question of the
Chair recognizes Mr. Manuel, question witness.
All right. I am a lover of history, and I know most people aren't because they find it boring, and I get that. What I guess my one question really is, can you explain what is the reason for districts like these and why they were created in the Voting Rights Act? Because I don't think most people understand why we have districts like these throughout the country.
Sure. I mean, these districts like these, I guess I want to sort of, there's a long history under the Voting Rights Act about aggregating voters in districts when they vote a certain way when a whole bunch of other conditions apply, majority minority districts and other districts of the like. I just want to be clear here that those are not the districts we're talking about right now because of Texas's claim, assertion that the Attorney General has made, that has been made under oath by your elected representatives, that race was not considered in the creation of these districts. So if you want to talk, we can talk about going back to 1982 when Congress amended the Voting Rights Act in response to the Supreme Court's decision in Mobile versus Bolden, recognizing that certain forms of electoral structures, particularly at-large districts, but also single district lines that divide communities where there is a history of discrimination, where there is racial bloc voting, where there's a distinct socioeconomic status, there's a whole literally laundry list of conditions, that the failure to create districts that allow voters to aggregate their votes in a certain way is a form of racial discrimination. And a form of racial discrimination under the Constitution and a form of racial discrimination under the Voting Rights Act as it was amended in 1982. And we can talk for a very long time about the case law that's developed over the years, Thornburg versus Jingles, onward through Bartlett and more recently, for that matter, on the intricacies of that doctrine. But the basic premise of it is the notion that political participation should allow at some level the aggregation of votes of communities, particularly communities that are protected by the statute. I guess I just want to add, though, I think that's actually not the question here, in part because Texas is not saying, has never asserted, and there's no indication that it drew these districts to comply with the Voting Rights Act or for any race-based reason independent of that, but rather wholly race-neutral considerations went into place. And it's now the Justice Department that's coming in and saying dismantle districts that one might even say organically developed as places in which minority voters are exercising are having a meaningful right to vote in them.
I promise I'm not moving your thing.
Further questions for the witness, Ms. Manuel?
No,
Okay.
I don't know what the mic, but no, she answered my questions.
Any further questions for this witness members? Hearing none, Dr. Katz, thank you for coming to testify today. You're excused. Chair's going to go to our in-person panel. I appreciate you patiently waiting for us.